In 1889, Copper King W.A. Clark and 74 other men wrote a state constitution to serve the needs of Montana's powerful interests, with a weak governor, a secretive legislature, and special tax deals for the powerful. After 60 years under the copper collar, Montana was declared the nearest thing to a colony of any American state. The Anaconda Mining Company even owned most Montana newspapers, the Copper Press. The corporate dominance of Montana's political affairs was unique in American history. 70 years after statehood, the Copper Press was finally sold, and thousands of World War II veterans had been educated under the GI Bill. Newly enlightened Montanans wanted out from under the copper collar, and big winds of change roared across the Treasure State. Changing Montana's constitution was the top priority. Strengthening the governorship, opening up the legislature, empowering citizens. Voices of Montana women, totally silenced in 1889, rang out loud and clear for these changes. When the Constitutional Convention began, 19 women were among the elected delegates. And when the delegates came together in convention, Democrats, Republicans, and Independents, men and women, young and old, sat alphabetically as equals, Montanans just wanting to make their state better. And so they did, producing a constitution for the ages, the last best constitution. Now at its 50th anniversary, Evan Barrett and real history makers of the time shine a light on the creation of this remarkable Montana Constitution.
Well, welcome back to Last Best Constitution, our series of historical discussions revolving around the 1972 Constitutional Convention and the amazing Montana Constitution that emerged from that convention. And we're doing this series at a very special time, which is the 50th anniversary of the Constitutional Convention and the Constitution. So as part of that, we've gathered together a wonderful group of folks who had up close and personal, as they used to say, experience about the Constitution and its development. Delegates, key staff members, and such. Our special guest today is Jerry Loendorf. Jerry was a delegate from Helena, Montana, an attorney here in Helena, and has been a practicing attorney, and he continues to practice a little bit even now at the age of, for 58 years. Jerry, welcome to Last Best Constitution.
Thank you, Evan.
Yeah. Now, you are not from Helena, although you were elected from here. You're from the northeast corner of Roosevelt County, Wolf Point?
Grew up in Wolf Point, yes.
Wolf Point. Yeah. And how'd that all start, and how did you end up in Helena? How'd that go?
Well, about my senior year in high school, my mother said to me one day, "I think you ought to go to college." And she says, "I think you ought to go to Carroll College." She says, "I've got their catalog, I've looked at it, you'll be happy there." And so in my home, when my mom said something, if I disagreed, the next day my father would say to me, "Mother and I talked it over and we think you ought to go to college." So I knew where I was going. And then...
so you came directly here to Carroll? Huh?
I came directly here, yeah. I came by train. It was a train to Great Falls, and there was a two-car train, I think, from Great Falls to Helena.
Went down through along the Missouri River there?
Oh, yeah.
Oh, yeah.
Yeah, my sister met me in Great Falls at the train when I was changing trains to get on the two-car train to Helena. I didn't know that's the type of train it was. And when she came up, I told her, "Geez, I can't find the train to Helena." She says, "That's it there."
Is that what they used to call the Galloping Goose?
It was the Galloping Goose.
The Galloping Goose, yeah.
Yeah, so I went to college here, then I went to law school over in Missoula, and after that I spent 6 months in the Army, and while I was in the Army I was corresponding with one of my classmates, Tom Harrison, who was here in Helena, and then a letter came in one day and he says, You know, my dad says they're short of clerks on the Supreme Court.
His dad was the Chief Justice.
Correct.
James T. Harrison.
Right.
Yeah.
And he says, you know, he's looking for clerks, and he said to tell you that. So, you know, I immediately wrote a letter of application because I had no plans once I got out of the Army. I was just in the Army for 6 months. And so I came back to Helena then and worked for the Supreme Court for about a year and a half. And Tom Harrison, who was, you know, a friend as well as a classmate, he and I started talking. He was working for the State Highway Department as a condemnation lawyer. And we decided to form a firm, and we did. I think we opened the doors in June of 1966.
Well, I first met you way back then. I was wondering if you were still clerking, because, but you were certainly working in that arena way back then. And when I was on the Reorganization Commission staff, and Tom was one of the Reorganization Commission members.
Right.
Yeah.
Yeah, I think he was a sponsor of the reorganization bill.
Yeah. In fact, Tom did a show with me and Sheena Wilson and Diana Dowling about executive reorganization in the Crucible of Change series. And it was you know, he's the last of that Reorganization Commission still around. And his dad was the Supreme Court Chief Justice.
Right.
How did that experience as a clerk serve you?
I thought it served me well. You know, I didn't come from a family of lawyers, and I didn't really know how they operated. And, you know, being a clerk, I got to observe a lot of them. I was able to observe, I thought, what was effective in the Supreme Court. It didn't give me experience in the district courts, and I had to gain that kind of just by walking in and trying cases once I left the Supreme Court. But it was a very good experience for me.
Yeah, I've always found that some of those positions we had, we didn't realize how important they were until we were done with them, and said, boy, I sure learned a lot from that, and it opened a lot of doors. And I think the clerk, for a young lawyer, being a clerk is an important thing. Yeah. So you now you're sitting there in Helena. You're a young attorney. You're in a law firm. What made you think about running for the Constitutional Convention? Did you ever run for politics before?
No, and never had thought of it before, and haven't thought of it since. But I think what got me was, you know, in Helena, you kind of have a front row seat to government. Yeah. And, you know, you just observe it. People talk about it more here because, you know, so many people work for it, federal, state, local. I think over 60% of the jobs in Helena at one time were
related
government
to that.
jobs.
Yeah, sure.
Yeah. And I was aware, you know, that the convention was coming, but I felt that legislators would be the delegates. You know, they were in perfect position to do it. They had experience at lawmaking. And so I never really thought about it much till I was listening to the radio in my car driving somewhere one day, and the news was on, and the state news mentioned that the Supreme Court had concluded that legislators could not run for the convention. And I just kind of realized then, you know, that's something I would like to do, and it's possible now.
Yeah. Well, yeah, you probably were just willing to just let the legislators have it and what the heck, but yeah, that was quite a decision. It was based on the old constitutional language, which still exists in the new one,
right.
that you can't hold two civil offices at the same time?
Right. It actually says legislators cannot be elected to another position during their time in office.
During the term for which they were elected, as I recall.
Right.
Yeah.
Yeah, because we had former legislators in the convention.
Right. So suddenly the door was opened. You thought, what did you think? I can do as well as anyone else?
Yeah, well, you know, my partner Tom and I, when we opened our office, we really didn't have any work to do, and one of the things you read was lawyers could always run for the legislature, so we talked about it, you know, and I said, you know, you should do it. Your name is Harrison, the Chief Justice's name was well known, there's another justice on the Supreme Court named Harrison, why don't you do it? And so he did, and we got together a small group of guys about our age and worked out a campaign. And so by the time the convention came along, I think I'd been through 3 campaigns with Tom and kind of had an idea, you know, what you did. And I used to be his campaign manager. We just reversed that. He became mine. And, you know, the convention was one that, or the campaign was one that worked out well for me. I didn't know a lot of people in Helena, and because, you know, in a law practice, it's not like a retail business. A retailer probably sees as many people in a day as you do in a law practice in a month. And so you're not well known, at least I wasn't. And, but at that time, I don't know why, maybe they always did, Helena's a well-organized town, has a lot of nonprofits, a lot of groups, social service agencies, I guess you'd call them. But they're always looking for speakers, and they would invite convention candidates in to speak. And how it worked out for me, I didn't have a lot to say about myself, so I talked about the Constitution, where
let me submit that clearly you were not an ordinary politician if you didn't have a lot to say about yourself. So, but, yeah.
Yeah, well, there really wasn't much to say, but you know, the other people did. They were mostly older than me. I think I might have been the youngest candidate in Helena as best I can remember. There were a lot of us. And most people talked about the things they had done, you know, how they had contributed to Helena, served as on the board of various nonprofit agencies. And they were good people and had done a lot of good things. So what helped me, I thought, was, you know, I was the only one that talked about the Constitution, and I could say things that I knew people would agree with. You know, you only had about 5 minutes at the most to talk, so you could talk maybe about a couple constitutional provisions and why it should be changed or why it should remain. And I frankly picked ones I thought people agreed with. And then the other thing that helped me, I thought, too, was this was what you call a multi-delegate district.
Multi-member district, yeah.
They elected 6 people out of this district. It was Jefferson, Broadwater, and Lewis and Clark counties was the boundaries of the district. But, you know, I knew there were some real good people in there, popular people, well-known people. I knew I could not run ahead any of those people. So I had a slogan to try to get the 3rd and 4th and or 4th and 5th, 6th vote of peoples, and it was vote for 6, but mark 1 for Loendorf. And I felt most people, you know, would only know a couple candidates well that they wanted to vote for, and if you had done something that might make them remember you, they might add you as one of their additional votes. And it worked. I just snuck by. I was elected number 6 in the primary, and I made it to number 4 when the general came around.
So you were number 6 among the Republican delegates at that time, and then number 4 overall in the general, because, well, that's a unique pitch. You know, you're going to have to vote for 6. You don't know them all. Remember Jerry Loendorf. We won for Loendorf. Huh?
Yeah, I didn't come up with that idea myself. A state senator, his name was Luke McEwen from Anaconda, told me, you knew him?
Oh, well, yeah.
Oh, yeah. Okay, but he told me once.
Luke was on the Executive Reorganization Commission with Tom Harrison.
Okay.
He was, yeah.
Yeah. Anyway, I knew him quite well, and he was telling me about how to campaign, and he says, and over in Anaconda we elect 4 people, and my slogan is vote for 4 but mark 1 for McEwen. So I just really took his idea as opposed to coming up with it myself.
He also ended up having his son be one of the younger delegates to the Constitutional Convention. Luke did.
Right.
Mick McEwen.
Mick just died a couple years ago.
He did, regretfully. And so your little experience as a campaign manager, by the way, your interrelationships with Luke, which again is an inter-party relationship. You know, it didn't matter he was a Democrat, you had a good relationship with him, got you your slogan, suddenly you're in the con-con. How'd you feel the day after the election?
You know, I can't remember real well, but, you know, I was so fortunate my whole life. Things always seemed to went my way. I kind of expected to win, you know, so I wasn't surprised by it. Although I wouldn't have been surprised had I lost either. Well, you know, then that was an early November election. And at the end of November, there was an organizational meeting of the con-con. Right. I think you met did you meet at the Colonial? No, we met at Carroll College. Carroll College, okay. Yeah. And you elected the leadership and ended up with Leo Graybill. Right. Did we elect the leadership then? We did. Yeah. Yeah. Right. Yeah, and I think the Democrats had ended up with Mags Osheim and Leo, and when it was, you know, it was 58 Democrats. It was a partisan election. 58, 36 Republicans, and 6 independents. Right. And so, de facto, it made sense that whoever came out of the Democratic group with the votes would get it. But I believe someone was nominated on the Republican side for nominally to just create a race. Right. It was done nominally, and there were I think the reason we had a candidate was there were some legislators, you know, in the group, former legislators. Yeah, who said this is the way you do it. They thought that's, you know, you shouldn't just go up there with nothing. Yeah, you know? Yeah. So Bruce Brown said he would be the candidate. And so he was a good guy, well liked by everybody, and he became a vice president of the convention then. Yeah. Now Leo had pretty much right off the bat said we're not going to be really partisan here. Which was he was very obviously had a partisan history. In fact, we did a filming on him in the Crucible of Change series. That was basically playing against type, that his type would be to be highly partisan, but he ended up being very bipartisan, nonpartisan. How did did you request the legislative committee when you were asked to request, or did you? Yes. I believe we all were allowed to request committees, and they tried to honor it. I think so, yeah. I think that was just tradition. Going back to the legislature, that's what they did. The speakers would always take requests from everybody. I think they would always say, give us your top 3 and we'll try to get you one. But and most of the time they were able to get most of the people on their, you know, number 1 pick, but always I think got them number 2, except for there were probably some occasions where they could not. But now Mags Osheim was the chairman of the committee, is that right? Right. And he was from up in Antelope, up by Glasgow? Yes, east of Glasgow, probably 70 miles. And he was a former legislator too. Right. Yeah, and so he was the chairman of the committee. How did you become selected as the vice chairman of that committee? How did that happen? Well, it surprised me. I was walking up to the chamber one day with Leo. We just happened to be walking together and chatting, and he says, you know, one of my young partners, Don Ostrom, knew your brother Joe in college. They both were at Montana State together. And he says, you know, Don thinks Joe's a pretty good person. And he says, in effect, we've concluded you must be too then. and I'm going to appoint you to as vice chairman of the legislative committee. You know, I mean, I didn't know what was going on. I hadn't even applied, you know, and wouldn't have applied. I mean,
Did you ever tell Joe that story?
I probably did, but I don't recall it.
With a deep sense of gratitude.
Yeah. And you know, that made me think back, you know, in later years when you're thinking about how did I get enough votes. You know, I did have 4 family members in Helena, Joe, one of my sisters, and uncle and aunt. And they were all, you know, well respected. And so I suspect I picked up some votes there just because I had the same name they did.
Yeah, yeah. So now you're in the legislative committee. Obviously, my recollection of my reading of history is that the terrible conditions of the legislature that existed, and people became aware of those weaknesses in the legislature, the secrecy and the other things that were going on in there, were one of the primary motivators for people when they were voting to say, let's have a convention. I think almost everybody knew there were real problems with the legislative structure under the old Constitution, and that caused it so suddenly we have an opportunity to change that. So as you approach that in the committee, what was the first thing that came to mind that needed to be fixed
To me, it was, you know, even out when we were campaigning, I talked about it a lot, and going into the convention was the restrictions on sessions, the restriction that limited the legislature to meet 60 consecutive days in a 2-year period. You know, that's 60 days out of 630.
Yeah.
And after that 60 days were up, you know, they had no control over the legislature. The Constitution further provided that the governor could call them in special session, but they couldn't call themselves in. And they were further, when they were called in special session, they were limited to the scope of his call. You know, if he wanted the budget taken care of, get the appropriation bill finished, he would limit it to that. So during those special sessions, what you had was a very inefficient legislature. During the 60-day session, you had people running around in a frenzy with way too much to do. You probably gave them 80 days work and told them to do it in 60 days. But once they got into special session, and there was maybe sometimes I think only the one item, you know, you had a couple committees working then, and everybody else, if spring was here, were out in the golf course looking for things to do. And it was a very inefficient operation.
Yeah. That was, under the old Constitution, 60 calendar days consecutively.
Right.
So usually that meant by early March you're done.
Right.
Yeah. And
They were.
And it was a pressure cooker situation to get that work done. And there was a very, once in a while they tried to stay overtime. But the rules, as I remember, were that if you were in the legislature and you needed to work any extra days beyond 60, number one, you couldn't get paid. So, but there was a little gambit they did, a little thing they did, so you could maybe go a couple days beyond 60, but without pay. How did they do that?
Well, they, in the House chamber, the time I saw it, they just had a big towel over the clock. And
yeah.
They pretended like they were still in the 60th day because they couldn't see the clock.
They would actually stop the clock at 11:59 of the 60th day and say, and not let it go to that extra minute until after they lifted that shroud over that towel over and so then they might do it. But they got their per diem, but they didn't get any salary. It was not very efficient or effective at all. And
and it was risky. You know, one of the court decisions, early court decisions that declared the Legislative Council unconstitutional, one of the bases for doing that is they said the legislature couldn't operate beyond 60 days through a council or otherwise. And so, I don't know where I was going with that.
But that made the point, though, that
Yeah.
you were done.
Right.
They were done after 60 days. And
Right.
then again, they became a tool of the governor at that point.
Right. So, but if they did go on beyond that 60 days, I got my point now, they had the risk of declaring whatever they did.
Whatever they did could have been.
Be unconstitutional.
Yeah, yeah.
So.
I did see that happen one time. I was just it was just a wonderful visual moment in my political history, in my governmental history, was watching them cover that up and say, okay, we can keep going now.
Yeah. I didn't see him actually cover it, but the time I was up there, I saw a ladder sitting there.
Getting ready.
Well, they had it up on there. They just left the ladder, I guess.
Yeah. I was staying there late one night, and I was watching it, and then they went right up there and did that. So basically, the governor at that point took over, and if they were going to have a special session, it could only be when the governor says, "I want a special session." It could only be what he wanted them to do.
Right.
And where now, when they come into session, a special session, once they're there, 50% of them can expand the call being the list of things they can do. Yeah. Mm-hmm. So that limited session stuff was a primary concern of yours when you got in the committee.
Oh, yeah, a major concern.
And you ended up with 90 days, and they didn't have to be they weren't consecutive, they were working days, right?
Yeah. 90
working days?
Yep. If they took Sunday off, it didn't count as a day against them.
Yeah.
Worse than.
And they could be, you could have breaks.
Right. They usually took a break halfway through of about 3 or 4 days. Then once they got into the operating under the new Constitution.
There have been some subsequent discussions that maybe they ought to, go to 60-30, 60 days one year and 30 the next year. That way but things have changed a lot since then with these interim committees. They don't seem to have such a desire for that anymore.
Yeah, and I don't know how efficient that would have been. The big thing they do is prepare a budget.
Yeah.
And that seems to take at least 60 days or longer.
Yeah.
So the fact that we ended up with a biennial session of 90 days, I'm not disappointed with. The Constitution, as you recall, was, when it was adopted, were annual sessions of 60 days each. And we had put in that sessions provision a sentence that said, I found it in another state constitution. We stole it, but it said in effect that bills would continue over to future sessions with the same status they had when the prior session adjourned during a biennium for which representatives had been elected. So once you had a new election, you had new people. You could not carry over bills, and they died because the same people didn't approve them earlier. But I thought that was important for management of sessions. If you were going to have 2 60-day annual sessions, once you got the budget done, it was probably a good time to adjourn. It was probably going to take you most of the full 60 days. And then any bills that were not completed, could just carry over to the prior or the next session with the same status. If you didn't have that, I thought you might have a mess. You'd have everything that was introduced.
Start all over again.
Yeah, and you would
beat
start
it once,
all over
have to beat
everything.
it again.
Yeah.
Yeah. But that annual session thing, that is most people don't understand that the convention did call for annual sessions.
Right.
Because what happened?
What happened to the annual sessions? Yeah, well, there was one annual session of the legislature.
The 73, 74
Right.
were the one cycle where we had 2 annual sessions. Yeah.
And then there was an amendment proposed to the Constitution to go to the biennial session of 90 legislative days. And that passed, and my recollection is it passed quite easily. And the people of this state just don't want the legislature in session too much. And the big argument that was made against annual sessions even during the convention was we'll end up with a professional legislature. And what people meant by that, they would have legislators who their main occupation was being a legislator. And people seemed to want them to earn a paycheck outside of their legislative duties that was their principal paycheck. And that's just what I picked up. There's never been any survey on that.
Yeah, and now that was a rural-driven initiative. I think that was the Farm Bureau did that lawsuit, I believe. It wasn't a lawsuit,
right.
An initiative.
Right.
And that happened. Well, that could never have happened before because limitations and changes in the Constitution had to come from the legislature under the old Constitution. Right. But you and the Con gave the opportunity for there to be constitutional amendments by initiative.
Right.
So that's, and the first one up changed the legislature back to biennial session, or biennial sessions.
Yeah. And the reason I wasn't too disappointed in that was, although I went out and campaigned for the annual session, the legislature still kept a lot of flexibility. It now had the ability to call its own special sessions. Plus, in there's a provision that says any legislature may extend the term of future sessions. So say if the legislature in 2030 we're finding, seem to be going over the 90 days, they might want to extend the session in 2032 to be 95 days.
So they got that flexibility, but then again, being sensitive to the electorate, they've never done that, have they?
They haven't, but they really haven't needed to. They seem to get the work done in 90 days yet.
Yeah. Now, one of the things that was part of what bothered people about the old legislature under the old Constitution was there were so many votes very few votes were taken on the record.
Right.
Committee votes were not on the record. Executive committee discussions were closed door, or votes were closed door. That irritated people an awful lot. And so the voting was a big change. We want to talk about that?
Yeah, that was probably my second major concern. And there are two provisions in the legislative article that deal with that. One says all substantive votes, whether they're in committee or in a regular session, are recorded. And the other provision that I thought was important says all sessions of the legislature, committee meetings, and hearings are open to the public.
Right.
So we, with those things, I think, got a people's legislature again.
Yeah.
It's and the good thing about that to me is those recorded votes and letting people see what's going on. People have, when they look at somebody's record now, they have like a report card. You know, just how well did this person perform for us? Did he do what he said? You really can't. People can't deny what their votes are. They're all right there. And it helps, I think, even the candidate that made the votes, because his record can't be misrepresented. The candidate opposing him, has to go after him on his record. And people will know what the record was. It helps, I think, both candidates and the voter.
I always remember I was asked to do a voting record on the 67 legislature. And they had a big, thick journal that had all the votes. But since they didn't take votes for the record on second reading, which is when most of the decisions were made, amendments and important decisions about it, and since they didn't have recorded votes in the committee, the only votes you really had were third reading votes. And by then, most of the results were already predetermined. By the time it got to third reading, people knew it was going to be passing. I remember doing that voting records and cutting and pasting them out of the journal onto pieces of paper, trying to create a record. And they'd all be 97 to 3 votes and 98 to 2 votes, because by then it was a fait accompli.
Right. Once it got to third reading, all the controversial amendments had been made, and it usually was like you say, it was pretty non-controversial if it made it to third reading.
So when I finished that massive voting effort, I thought, what did I do this for?
Yeah.
Not a real, it was of insignificant value to a voter.
Right.
To look at that. And so you were right as a con to allow the creation of a record.
You need a record all the way through. When someone votes on a bill in committee or an amendment to committee, that changes the bill.
Yeah.
And when it gets to the floor, amendments are taken on second reading too.
Mm-hmm.
And those are sometimes quite controversial. So when those things have all been decided, I think a lot of times on third reading, people just figure they've had their vote and they go along with the majority, because third reading often passes with a better vote than second reading.
Yeah. Yeah, I think there's a lot of that. Well, it's going to pass now.
Yeah.
And unless you have a really stern objection to it, you say, well, I'll just go along with this, and maybe I'll maybe I'll be more friendly with the sponsor,
Yeah.
or something like that. Now, built into this is these votes, built into the larger picture item, not just for the legislative committee, but for the whole con, which is the public's right to know. That was a big concern of yours through all this.
Yeah, and we principally tackled it in the legislative article, but just for the legislature. What the Bill of Rights Committee did that was so much more valuable than what we did, they opened up government to people at every level, state government, county government, city government, school districts. Any form or unit of government is subject to what's called the right to know. That's would be Section 9 of Article 2. And what it provided was that people could attend and observe the deliberations of any public bodies and also review documents. So people could not only hear what was said, but see the documents. And that's, I thought, was essential. And how I think it will work out well, and has worked out pretty well, is along with the provision that we have in all constitutions providing for freedom of the press. Mm-hmm. Us people, when we're working, we don't have time to be going to a government meeting every day, and they're going on all the time. But the press can, and they do, and they're really the people that tell us what's going on. Mm-hmm. If we didn't have a free press, I think a democracy wouldn't function that well.
Yeah, I think that that's, in fact, one of the things that Thomas Jefferson talked about. Both the education and the knowledge of the electorate was essential to the functioning of democracy, and the free press was a big part of that.
Right.
In addition to the right to know, which is a segment of the Bill of Rights, there was I understand that, I've never had anyone correct this, that the only state constitution in the nation that has a constitutional right of participation is Montana.
Right.
And that participation is different than just, can I know about it?
Yeah, that's in Section 8. The right to know is Section 9. The right to participate is in Section 8.
Of the Bill of Rights.
Yep.
Yeah.
And what it says, in effect, is that people have to be given a reasonable opportunity to participate in government functions before final decision. And then it concludes, as provided by law. So the legislature has to act. The section isn't self-executing. In other words, like the right to know Section 9 is. It operates by itself. But the legislature has, enacted a couple at least, pieces of legislation, one being the open meeting law, and the other one that simply requires notice be given, and people be given access and the opportunity to attend if they can.
So when whether it be a legislative hearing, whether it be an action by a board on the state government board or a county board or the county commission,
Right.
or whether it be any kind of activity like that, a school board, the right of participation ends up requiring there to be an agenda that says, here's what we're going to take up, and here's what we're going to do, and this is an action item, and this is not, and things like that. When that happens right now, that's been happening for 50 years, but that wasn't the way it was before the Constitution.
Right. Right. Everything was done privately, really. You know, the executive branch, all their people met privately. There was no notice given or anything.
Under the Administrative Procedure Act, whenever there's a hearing on anything, and if you want to
Yeah.
be, if you end up, you can either read about it in the paper or you can be on a mailing list. You're going to find out what's happening. You can participate in one way or another, including testifying.
Right.
And that is something that's been in place for 50 years, and people that think it's always been there are in error.
Right.
Yeah.
It's, 50 years is a long time, and it's hard for people to, I think, see what it was like before we had the constitutional changes. And people pretty much assume it's always been this way, that you could always go to the school board meeting or go to the county commission meeting, go down to see your city council in action, but that wasn't the case. I mean, they didn't even, I don't even think, told people when they were meeting.
Yeah, and there's a provision that says, or interpretation of it that says, you can't have a meeting of a quorum of a committee outside of the formal committee meeting. If you have a quorum present, it's de facto a public meeting, and you can't do that.
Right.
And that was the old thing with, you couldn't have two county commissioners going to the men's room or the women's room together because they could be a quorum. But I think it's one of the important things that we need to recognize is that this belief. I think Montanans are very strongly supportive of the Constitution the way it is, but most presume it's always been that way. If you're under the age of 50, you have no idea what it was like before, and many people weren't aware of it anyway. And so this presumption that it's always been that way belies the situation that the Constitution brought real change to Montana. And we need to, I believe we need to make people aware that it wasn't all this comfortable in the past. And if you went back to the old ways, they would not be really good for citizens. You guys did a good job for citizens.
Yeah, and that was one of the focuses. And it was just no secret. I mean, everybody knew how government operated, and we had people coming to the committee. Our committee was open all the time, and people would come in, and we just invite them to talk. And there was one couple particularly that was advocating open government, opening up government. They were from Great Falls, but we had people in from as far away as Medicine Lake. People came to the convention.
Even beyond Wolf Point.
Yeah. Yeah, still in Montana.
Yeah, still out there. Yeah. Well, I think the Constitutional Convention is to be complimented for and appreciated for this openness stuff, probably as much as anything. That's a hallmark of Montana government.
Yeah. If we think about it, all constitutions that I know of begin with "we the people."
Yeah.
It's the people's government. The government doesn't exist separately. We own it. And the people we elect are people they're sent to work for us and, pursue our interests. It's not the other way around. People are not subjects of government. Government is the subject of the people, I think.
Yeah.
And if people, and that's the way it really is, and if people just understand that, and if government officials would understand that, I don't think they'd ever want to close a meeting. But it's just, I've never been able to figure out why people, once they're elected, you know, they have a tendency to want to go private.
Yeah. Oh, it's automatic almost.
Yeah. It's and I don't know that they understand that, you know, the people that elected them are really their boss.
Yeah. It's a strong philosophical basis of government that, but often when people are elected and empowered by their election, they take that power seriously and want to exercise it however they want to. I mean, maybe that's a little bit of human nature too. It's a human nature for the citizenry to want to know. It's human nature for leadership to say, well, don't bother me with all those niceties. Yeah. I've got stuff to do here, agendas and things. But I think it is emblematic of that. You see it, and almost always, every legislature seems to want to find a little way to nip a little bit of openness away and find a little way to be secretive.
Right, I agree, and I never understood it.
Yeah. Well, that's because you're not a politician, but you are a philosophical convention delegate who has something behind what you were trying to vote on. The open government, right to know, right to participate, power of the people. Wow. You know, when you study, since the Constitution is a fundamental document in the law of a state or a nation, that fundamental document dictates the way things are, and people are constrained by it. I mean, the government's often the structure of a constitution limits. It delineates what government's to be doing, but it also limits what government can be doing. And when people get in charge of government, they tend to want not to understand those limits. They've got kind of their own way of doing it. I just see that and know that people of Montana would not like living under the old Constitution.
I would definitely not like it now. I mean, if you tried to go back there now, people would rebel.
You know, and yet, you know, when you're in the legislature, and I guess I don't have to lobby the legislature anymore at my age, but to say that legislators tend to think, well, we know everything needs to be done, so don't bother us with all this other stuff.
Yeah.
We need to know all this stuff. Well, I have a great faith in the institutions of government, but one of the institutions I have a great faith in is that inherent structure of the people owning the government. And in the old Constitution was written much to serve the needs of the large economic interests of Montana at the times. A lot of it to do with mining, large agriculture. These powerful interests of 1889 wrote a constitution to serve their needs, and it was a big. When you create a new constitution that empowers people instead of economic interests, that's a big change, and economic interests don't give that up easily. They're still looking to find ways to go back, I think, on this constitution.
Oh yeah, and you know, it's important, I think, to be able to distinguish what belongs in a constitution from statutory law.
Yeah.
It's a constitution is a supreme law, and to me, it shouldn't do any more than provide for a structure for government and set forth our primary rights, like the U.S. Constitution does and the Montana Constitution do in their Declaration of Rights. And they both set forth a structure of government dividing powers among the legislative, executive, and judicial, and that's one of the way us peoples keep control. But what concerns me is there's so many people out there that don't seem to recognize that distinction. It wasn't too many years ago someone was proposing an initiative, and they were interviewed in the newspaper, and the person said that she wanted to set forth a provision concerning regulation of marijuana. It was in the Constitution. And because the Constitution was more difficult to amend. And, you know, the Constitutions are more difficult to amend for a reason. You know, they're to be the stable, setting forth general principles and a structure, and not much more than that. Whereas the statutory law deals with all the details. It's what comes out of the legislature. You know, like a fish and game might have legislation where they want to change hunting regulations. You know, the harvest was too
Doesn't sound
too
like a
good last
constitutional
year.
issue, does it?
Right.
Yeah.
It's and you'll ruin your Constitution if you fill it up with statutory language.
And yet people, if people believe I've got a special interest, and my special interest is so important that I want to protect it from being changed easily. Let me
Right.
get it in the Constitution, and then I can be more protected. And we have a couple instances of that, one of which is a simple one, and one of which is complex. This Marcy's Law thing from a few years ago.
Yeah.
Tell me about that.
Well, that was, I don't know all the details of it, but it was a constitutional initiative, and it's
So it
now
came
part
from the
of the Bill of
grassroots and got
Rights.
signatures.
Yeah, and it's to, you know, provide remedies for victims of crime, restore, you know, what they've lost, or
Right.
it deals with that. And, you know, those things are things that you change frequently.
But here we have it now in a it's in the Bill of Rights.
Yeah, and it's,
Isn't it as long as the rest of the Bill of Rights
by
combined?
itself, it appears to be, you know, and like that, those sets of books there, your Constitution, instead of being like the little one on the end,
Yeah.
will end up to be essentially the size of all those volumes.
So suddenly we have all the minutia in what is a fundamental document. That came because of the initiative process,
Yeah.
which had, I guess that's the old double-edged sword. There's all that wonderful things that come from the initiative, and then the downside of it is something like that ends up in the Constitution.
Right. And, you know, you pointed out in a paper once how much of the old Constitution was legislative material, that it took up about 2/3 of the
Yeah.
old Constitution, legislative material. And the Legislative Council, you were citing a Legislative Council study, had gone through the old Constitution when they were thinking about calling a convention, and identified all of that statutory material that was in the old Constitution.
Fully 30% of the constitutional sections needed to be removed.
Yeah.
And, you know,
That's what they said, and I
Yeah.
remember your report on it
Yeah.
a few years ago.
yeah. Well, that was a wonderful Legislative Council study, which there was so much came into this, you know, the League of Women Voters research and the Legislative Council study and the Revision Commission. All that stuff was leading up to this vote in November of 1970, in which 65%, 2-1, 65% of the Montanans said, we want to have a convention to change our Constitution.
Right.
Now, an interesting thing is that once it was written, and it changed the power structure from a corporate dominant constitution to a people dominant constitution, there was a lot of opposition from the ones that were losing power in that 75-day election till it was voted on. And in that period, that 65% support for calling a convention whittled itself down to 2,500 vote margin. You know. Now, by the way, that I want to talk to you very quickly because you had a unique role in protecting the Constitution once it was passed in terms of court cases. Can you talk a bit about the several court cases that you helped handle for the Constitutional Convention?
Yeah. The first one was the Constitutional Convention had saved some money to use for voter education during the campaign. And it also had applied for a grant with, I believe it was HUD from the federal government. Yeah. But what we did before we adjourned is we adopted a resolution that said, in effect, we've completed our substantive work. We've adopted a constitution.
We want to use the leftover money.
There's some procedural things to do, including the spending of that money. And that was a case that went to the Supreme Court. I was involved with it along with Marshall Murray, and there were other people involved. And we prepared and briefed and both argued to the Supreme Court. And I'm convinced that had we won that case, we would have lost the election. Yeah. Because that would have created one more issue. Right. You know,
public money, spending public money to tell you what to do.
And you can't, if somebody can point to you and say you're spending some money you weren't authorized to spend, you're hurting. You know, you're not going to win
But you lost
an election.
that case.
Yeah, I did. You know, and there was just such a fine line between, I think, advocating for something and educating. Yeah. I mean, the same statement but can be considered both. And I think had we spent that money, we would have had to face the argument that, you know, you use that education money to advocate for passage. Yeah.
Now you also, you lost that one, but you also then, it was a challenge on the court count. You handled that case substantially?
Well, I prepared the brief.
We only got a couple minutes left.
But I prepared the brief for the one all the attorneys on the convention signed. And it was not a complicated brief, but the essential thing was that the only votes that could be counted were the ones that actually voted on the issue, shall we adopt the Constitution, whether you were for that or against it. What the opponents wanted to do was, the opponents of the Constitution, was count as no votes people who didn't vote on that issue, but otherwise voted in
like
another
on the
election.
Side issue.
Yeah. Had they been able to prevail on that issue, there were enough non-votes, had they been able to count those as no votes, to change the result.
You found some old cases and that made that point, and that we did win by 2,500 votes and a 3-2 vote on the Supreme Court. Is that
right? That's right. And then it was retried again in federal court, and the vote was 3-0. It was a 3-judge federal court, which is you know, a special court. Right. And so, yeah, it was a long, hard fight.
Well, thank you for your role in that. We're about to wrap up here, Jerry, and I want to just say that we appreciate you being here, sharing your wisdom about the legislative article, your involvement in this in so many important ways. And, you know, those of you that wrote this, 100 people that wrote this Constitution, in my eyes, are real Montana heroes and will always be that. And so thank you for what you did in the Constitution. Thank you for coming here on Last Best Constitution. We hope this is going to help illuminate the Constitution to many Montanans. And thanks for being here. And for all of you that have been watching, be sure to tune in next for the next version of Last Best Constitution.